Man, I'm so motivated to study today. Man, I'm so motivated. I'm feeling so positive. So positive. Everything is fine. Everything is going fine. Man, let's start. Appointment and qualification of directors. Let's do. Company must have a board. Section 149. So a company must have three minimum directors. A company must have two minimum directors in case of a private company, and if it's a OPC company, then one minimum director. The maximum number of directors are 15 for all companies. Want more? Then you have to pass a special resolution. What are the types of directors you must know? Simple. Woman director, compulsory for every listed company, compulsory for any other public company with paid up capital of greater than or equal to 100 crores, or a turnover which is equal to or greater than 300 crores. New company has 6 months to comply, and the vacancy must be filled within next board meeting or 3 months, whichever is earlier. This was for women directors, and for resident directors, every company must have at least one director who stays in India for greater than or equals to 182 days in a financial year. So this is again for every company. Woman director was for every listed company, every other public company, and any company with a turnover of greater than or equals to 300 crores. The new company has 6 months to apply, and vacancy must be filled within the next board meeting or 3 months, whichever is earlier. Independent director, unbiased outsider on the board to protect minority shareholder interests. Detailed provisions discussed in section 12 below. Interested director, a director who has a personal interest in a company transaction, must disclose it at the right time. Executive director actively manages day to day operations, example, managing director or a whole time director. Non executive director participates in policy making through board meetings only. Example, nominee director, independent director. Liable only if they knowingly consented to wrong acts. Okay, that's fine. Exemptions, remember. Government companies, no default in filing, plus Section 8 companies, no default, are exempt from the 15 director maximum rule. That is, they can have more than 15 directors, but only if they have made no defaults in filing. For Section 8 companies and government companies. Appointment of directors, Section 152. Who are the first directors? Usually, the articles of association name them. But if articles are silent, individual subscribers to memorandum deemed first directors, not corporate bodies. For one person companies, the individual member is deemed the first director, and term of first directors ends at the first AGM. Subsequent directors, rule of thumb. Every director is appointed by shareholders in a general meeting, exception where the Act expressly provides another route. Example, additional director appointed by board. Checklist before appointment. DIN. Director must have a valid director identification number. Furnish DIN plus declaration. Must declare he is not disqualified. Section 152, subsection 4. Written consent. Give consent in form DIR2 on or before appointment. Company files with the registrar in form DIR 12 within 30 days. And security clearance, you get extra requirement if director is a national of a land border country. Okay. So the exam note here is that for independent directors, the notice of general meeting must include a statement that, in board's opinion, he fulfills the independence conditions. So again, we'll do this again. Checklist before appointment. So the director must have a DIN. Second, he must furnish the DIN with the declaration that he is not disqualified under section 152.4. And should give a written consent in Form DIR-2 on or before appointment. Company files with the registrar in Form DIR-12 within 30 days, and security clearance if the director is a national of a land border country. So that means Pakistan, Nepal, Bhutan, Bangladesh, and maybe in that side, Burma, Myanmar. So if he's a national for this, he must get a security clearance. And the independent directors, where the matter of appointment of independent directors will be taken up. The notice of the general meeting to that meeting must include a statement in the board's opinion that the board is of the opinion that the director fulfills the independence conditions. Require retirement by rotation, section 152.6, very important. This prevents a self perpetuating management board controlling itself forever. Here's how it works: applies to public companies and private companies that are subsidiaries of public companies. So it applies to all public companies, whether listed or not, and also to private companies that are subsidiaries of these public companies. Step: exclude from count rule: independent directors plus nominee directors are not counted. Example: 10 directors, 10 minus 2 independent directors equals to 8 directors. Okay. So independent directors and nominee directors are not counted. Rotational directors, at least two-thirds of remaining directors must be rotational. So let's say there are 10 directors including two independent directors. So first, for calculating this, we'll not include the independent directors. So there's 8 directors remaining. Of this 8 directors, we'll calculate the two-thirds. The two-thirds of 8 directors will be 5 to 6 rotational. So at least two-thirds must be rotational, who retires at AGM. One-third of the rotational directors retire at AGM. So the one-third of this further 6 shall retire at AGM. So two shall retire at AGM. Which one retires first? Those who have been longest in office since last appointment. If tie, then mutual agreement or lot. Okay. So if both of them have been from the same time, then in that case, either one of them, through mutual agreement says, "Oh, I'll retire," or it's a game. They'll play a game probably to decide who retires. Key rule: if AGM is not held on due date, retiring directors must vacate office on the due date itself, not extended to actual AGM date. Okay. So, in case of rotation, if AGM was not held on the due date, director must vacate office on that day, regardless of whenever the next AGM will be actually held. Deemed reappointment, section 152.7. If retiring director's vacancy is not filled at AGM and the meeting doesn't resolve not to fill, AGM adjourned to the same day next week. If adjourned meeting also doesn't fill vacancy, director is deemed reappointed. Deemed reappointment does not apply if resolution for reappointment was put and lost, director expressed unwillingness in writing, director is disqualified, or special or ordinary resolution required by law, section 162 is violated. So if these five situations happen, then deemed reappointment does not apply. Resolution for reappointment was put and lost. Director expressed his unwillingness. Director is disqualified. Special or ordinary resolution required by law, or section 162 is violated. And what is deemed reappointment? Deemed reappointment is if a retiring director's vacancy is not filled at AGM and the meeting doesn't resolve not to fill, AGM is adjourned to the same day next week. If in the adjourned AGM also the vacancy is not filled, director is deemed reappointed. Director identification number, section 153 to 159. Simple analogy. DIN is like a PAN card for directors, one unique lifetime number per person. DIN is also equal to DPIN, which is the designated partner identification number for LLP purposes. Application process for DIN, right? File form DIR-3 electronically with central government plus prescribed fees. Okay. Attach a photograph, proof of identity, proof of residence, board resolution, specimen signature. Fine. Form signed with digital signature certificate verified by company secretary, MD, CEO, CFO of a company. System generates application number on payment. Central government communicates approval or rejection within 1 month. New company incorporation up to three proposed directors can get DIN through form INC 32 SPICE through in during incorporation itself. So up to three proposed directors can get DIN through form 1 INC 32 during incorporation itself. So this is for new companies obviously. Key DIN rules summary. Allotment: CG allots DIN within 1 month of application. One DIN only, cannot apply for more than one DIN ever. Director informs company within 1 month of receiving DIN from central government. Company informs ROC within 15 days of director's intimation in form DIR 3C. What was DIR 3C? It was the filing form electronically with central government plus prescribed fees. Must mention in every return or filing that refers to a director must include his director identification number. DIN is valid lifetime once allotted, valid forever, cannot be given to anyone else. When can DIN be cancelled or deactivated? Rule 11. Duplicated DIN. Two DINs for same person. Data merged. Wrongful or fraudulent. Obtained by false documents or misrepresentation, right of hearing given first. Death of the individual, declared unsound mind by court, adjudicated insolvent, surrender form DIR 5 if never appointed as director anywhere, non filing of KYC, direct DIR 3, KYC not filed within time, deactivation file form DIR 3 again with prescribed fees. Penalties. Section 157. Company fails to furnish DIN to ROC, 25,000 rupees penalty plus 100 per day for company and each defaulting officer. So maximum up to 1 lakhs. And section 159. Company director violates section 152, 155, 156. Penalty up to 50,000 rupees or 500 per day of continuing default. Section 5. Right of others to stand for directorship. Section 160. What is this? Who is this for? A person who is not a retiring director but wants to become a director. Process. Give written notice to company's registered office at least 14 days before the meeting, signed by the candidate or proposing number. Deposit 1 lakh with the notice, 10,000 for needy companies. Company informs member at least 7 days before meeting electronically on website via newspaper. So, what is this? A person who is not a retiring director but wants to become a director. Process. Give written application to company's registered office at least 14 days before the meeting. Deposit 1 lakh with the notice and company informs members at least 7 days before meeting electronically. Deposit refunded if person gets appointed as director, gets more than 25% of total, uh, you know, valid votes. No deposit if independent director being appointed, uh, director recommended by nomination and remuneration committee, director recommended by board where no NRC. Exemptions from Section 160. Government companies, 100% government capital, their wholly owned subsidiaries, private companies, Section 8 companies with ballot elections, all are exempt if no default in filing. Okay. Small shareholder director, Section 151. Listed companies may not mandatorily have one director elected by small shareholders. Small shareholders hold shares of nominal value of less than or equal to 20,000 rupees. Rules at glance. Who can propose? Greater than or equals to 1,000 small shareholders or 1/10 of total small shareholders, whichever is lower. Notice period at least 14 days before the meeting. Status: treated as an independent director, must fulfill all independent director criteria. Tenure max 3 consecutive years, not eligible for reappointment after that. Rotation: not liable to retire by rotation. Maximum companies Max companies can hold small shareholder directorship in max two companies at a time. Second company must not compete with first. This is also a second condition. Cooling period 3 years, cannot be associated with the company in any capacity after ceasing. Additional alternate nominee slash casual vacancy director section 161. Additional director appointed by board of directors if article permits. Cannot appoint if person has failed to get appointed at a general meeting, no backdoor entry. Tenure till next annual general meeting or last date annual general meeting should have been held, whichever is earlier, and not a retiring director. It needs to be regularized, follow section 160 procedure. Alternate director section 161 2. Whoa. When original director is outside India for more than or equals to 3 months. Appointed by the board if articles or general meeting resolution permits. Cannot be already an alternate for another director in same company or already a regular director in same company. For an ID's absence, alternate must also qualify as an independent director. Tenure cannot exceed original director's permissible term, must vacate when original returns to India. Who appoints? Board appoints, not the original director himself. Exam classic. If original director's term expires while he is abroad, original director, not alternate, gets deemed reappointed under section 152(7). Nominee director, section 161(3). Appointed by board subject to articles when nominated by a financial institution, example bank that gave a loan to protect its interests at central or state government by virtue of shareholding in a government company. Not an independent director stays on board till loan is repaid, government decides to or the government decides to remove. Casual vacancies, section 161(4). A director appointed at general meeting vacates office before his term expires due to death, resignation, disqualification, removal, etc. Not due to retirement by rotation. Filed by board at board meeting. Approval must be ratified at immediate next general meeting. Tenure of new director only till the date the original director's term would have ended. Chain rule: if the casual vacancy filler seat again falls vacant, that is not another casual vacancy since he wasn't appointed in general meeting. Board must reappoint additional director instead. Moment slash independent director vacancy must be filled next board meeting or 3 months, whichever later. Individual voting for directors, section 162. The rule: each director must be appointed by a separate resolution. You cannot bundle two or more directors into one vote. This would deprive shareholders from rejecting a specific person. Exception: two or more directors can be appointed in a single resolution if a proposal to do so was first put before the meeting and was agreed to with zero votes against. Okay? Even one vote against not allowed. Consequence of violation: resolution is void whether or not anyone objected at the time. Exemptions from section 162: government companies and their wholly owned subsidiaries and private companies, if no default in filing, have exemptions from section 162. Proportional representation, section 163. So why does this exist? Normal voting equals to majority wins 51%. Minority shareholders, even with 49% votes, may get zero directors. Proportional representation fixes this by ensuring minority shareholders get a fair share of both seats. Point. Override. Section 163 has overriding effect over all other provisions of the Act. How enabled? Must be in the articles of the company. Coverage: at least two-thirds of total directors via proportional representation. Voting methods: single transferable vote, cumulative voting, or any other transparent method. Frequency: appointment made once in every 3 years. Casual vacancies filled as per section 161.4. Cannot be removed. Disqualifications appointed via proportional representation cannot be removed by shareholders. So sorry, directors appointed via proportional representation cannot be removed via by shareholders. Disqualifications for director, section 164. UI code DN. Unsound mind, insolvent or pending, conviction, 6 month sentence or 5 year block, order of court, calls unpaid, 6 months, dealings, RPT last year, no din, not complied, section 165. So, disqualification, unsound mind declared so by a competent court, undischarged, insolvent, pending insolvency application applied to be declared insolvent, convicted and sentence greater than or equals to 6 months, block of 5 years from sentence expiry. If sentence greater than equals to 7 years, permanent ban. Okay. Court or tribunal order, disqualification order in force, calls unpaid calls on company shares plus 6 months elapsed. Related party transaction, conviction, convicted under section 188 in last 5 years. No DIN has not complied with section 152.3. Exceeds directorship limit has not complied with section 165.1. Section 164.2. Company based disqualifications. A director gets disqualified for 5 years from the date of default if the company he directs. Just a second. Yes. So, company based disqualifications, a director gets disqualified for 5 years from the date of default if the company he directs has not filed financial statements or annual returns for 3 consecutive financial years, or has failed to repay deposits or interest on deposits, failed to redeem debentures or pay interest, failed to pay declared dividend, and this failure continues for greater than or equals to 1 year. Grace period: if a fresh director joins a defaulting company, he gets 6 months grace from his appointment date before disqualification applies. Effects on offices: under section 164.2, office becomes vacant in all other companies except the defaulting one itself. Section 164.3, private companies power. A private company, not subsidiary of a public company, can add additional disqualification in its articles. Only, example, only graduates can be directors or must hold X shares. Okay, fine. So this is not for public companies, only for private companies. Acha, effect for 164.2, there's a effect that office becomes vacant in all other companies except defaulting one itself. Okay. Maximum number of directorships, section 165. So max 20 total companies including alternate, 10 max public companies includes private companies that is holding or subsidiary of public companies, and 0 dormant companies and section 8 companies not counted. Okay. Members can restrict further. By special resolution, members can specify an even lower number. Penalty for violation: 2000 per day of violation, subject to a maximum of 2 lakh rupees. Section 12. Independent directors, section 149. Who must appoint independent directors? Every listed public company, at least one third of total directors. Public company with paid up capital greater than equals to 10 crores, at least two independent directors. Public company with turnover greater than equals to 100 crores, at least two independent directors. Public company with outstanding loans, debentures, deposits greater than equals to 50 crores, at least two independent directors. Not required for joint venture, wholly owned subsidiaries, dormant companies, exempt from Rule 4.1. Also, if company ceases to meet conditions for 3 consecutive years, appointment is not required. Who qualifies as an independent director? Section 149(6). Must not be a managing director, whole time director, or nominee director, and must satisfy all of these. Persons of integrity with relevant expertise in board's opinion, not a promoter of the company or its holding subsidiary associate not related to promoters or directors, no pecuniary relationship with company except remuneration or transaction less than or equal to 10% of its total income in past 2 financial years or current financial years. None of his relatives hold greater than 50 lakh or greater than 2% of securities indebted greater than 50 lakh, given guarantee greater than 50 lakh, or have greater than 2% pecuniary transactions. Neither he nor his relatives were key management key managerial persons employed in last 3 years, were auditors or legal consultants greater than 10% of their turnover in last 3 years, hold greater than equals to 2% of voting power, are CEO of a non-profit getting greater than equals to 25% from the company. Skills in finance, law, management, marketing, etc. Rule 5. Tenure, remuneration, and other key rules. Term up to 5 consecutive years per term. Reappointment needs special resolution. Maximum terms, maximum 2 consecutive terms. Cooling period after 2 terms must wait 3 years before reappointment in same company. Retirement by rotation, no. Independent directors are not liable to retire by rotation. Entitled to sitting fees, section 197.5 plus expense reimbursement plus profit related commission. Not entitled to stock options. Declaration must declare independence at first board meeting he attends, first board meeting of every financial year or any change in circumstances, must abide by Schedule 4 of the Companies Act. Liable only for acts done with his knowledge through board processes with consent slash connivance or due to lack of diligence. Separate meeting must hold at least one meeting per year without non-independent directors. Removal. Second term independent director can be removed only by special resolution. Independent director appointed mandatorily for good governance protects minority shareholders. Appointment approved by general meeting must declare independence. Nominee director appointed to protect financial institutions' interest stays till loan is repaid. Not truly independent cannot substitute for an independent director. Data Bank of Independent Directors, Section 150. An online database of individuals willing and eligible to act as independent directors, maintained by the Indian Institute of Corporate Affairs, Manesar. Apply online to IICA for inclusion for 1 year, 5 years, or lifetime. Pass online proficiency self assessment test within 2 years of inclusion. Pass equals to score greater than equals to 50%. Unlimited attempts. Renew registration within 30 days of expiry, not needed if lifetime fees paid. Submit compliance declaration to board every time you give independence declaration. Exempt from proficiency test. Serve greater than equals to 3 years as director, key managerial person in listed large public companies or individuals who have been for greater than equals to 10 years an advocate, CA in practice, cost accountant in practice, or CS in practice. Duties of director, section 166, act per articles plus Companies Act, simple meaning follow the rule book, act in good faith, promote company's objects, act in best interest of members, employees, community, environment. Exercise due care, skill, and diligence plus independent judgment. Do your homework before voting. No conflict of interest. Don't put yourself in situations where personal interest clashes with company. No undue gain. If found guilty of undue gain, pay that amount to company. Cannot assign office. You were elected personally. You can't hand your role to someone else. Delegation to staff not equals to assignment of office. Okay. So again, is liable for independent directors? Every listed public company with paid up capital greater. Okay, fine. Other key duties: non-exhaustive, file documents with ROC on time, convene AGM and EGM as required, attend board meetings 4 per year minimum, gap less than or equals to 120 days, disclose interest in transaction at first board meeting after become interested, approve annual financial statements before auditors report, approve and attach board report with financials, appoint first auditors. Penalty for section 166 violation: fine minimum 1 lakhs to maximum 5 lakhs. Vacation of office of directors, section 167. Grounds for vacation: incurs disqualification under section 164, 164(2), vacates all companies except the defaulting one, absent from all board meetings for 12 months with or without leave, enters contracts which where he has direct or indirect interest, contravening section 184, fails to disclose interest, contravening section 184, disqualified by order of court or tribunal, convicted and sentenced to imprisonment for more than or up to 6 months, more than or equals to 6 months, removed under any provisions of the Act, appointed due to holding employment in holding slash subsidiary company, loses that employment. Grace for E and F. So point C, as disqualified by court or tribunal, convicted and sentenced to imprisonment greater than or equals to 6 months. Office not vacated for 30 days for from conviction or order if appeal filed within 30 days until 7 days after disposal, further appeal until disposal. Okay, I have some doubts here. When all directors vacate, section 167(3), promoter shall appoint new directors. If no promoter, central government appoints new directors, hold office till company appoints directors in general meeting. Penalty for continuing after vacation: 1 lakh to 5 lakh for the director who acts knowing his office is vacant. Resignation of director, section 116. Director sends written notice of resignation to the company. Director sends written notice of resignation to the company. Board takes note of the resignation. Company files with ROC in Form DI at 12 within 30 days. Resignation mentioned in board report at next general meeting. Director himself files copy of resignation plus reasons in Form TIR 11 within 30 days. Effective date: resignation effective from date company receives notice or date specified in notice, whichever is later. Liability continues. Resigned director is still liable for offences that occurred during his tenure. Removal of directors, section 169 to plus section 242. Removal by shareholders, section 169. Scenario: general removal of any director before term ends. Resolution type: ordinary resolution. Removal of second term independent director, special resolution. Director appointed by tribunal under section 242 cannot be removed by shareholders. Director appointed via proportional representation two-third rule cannot be removed. Special notice required signed by members with greater than equals to 1% of voting power or shares with greater than equals to 5 lakh paid up, sent not earlier than 3 months but at least 14 days before meeting. Company sends copy of notice to the director concerned. Director has right to be heard at the meeting plus can send written representation to members. If meeting votes for removal, director removed, vacancy may be filled at same meeting if special notice for new appointment was given or a casual vacancy. Key points: removed director cannot be reappointed to fill casual vacancy created by his own removal, is entitled to compensation or damages for premature termination. New director serves only the remaining term. Removal by tribunal, section 242. Tribunal can remove a director when application under section 241 operation and mismanagement is made. Director removed by tribunal gets no compensation, cannot be appointed as directors for 5 years without tribunal's leave. Register of directors, Register of Directors and KMP, section 170. What must be maintained? Every company keeps a register at its registered office containing details of all directors and key managerial persons, including their DIN, contact info, nationality, appointment or cessation dates, and most importantly, all securities held by them in the company plus holding or subsidiary associate companies. Filing requirement: file return in form DIR 12 within 30 days from date of appointment or any change. Members' right to inspect. Section 171. Access rules. Register to open for inspection during business hours. Members can take extracts and copies provided within 13 days free of cost. Register must also be open at every AGM. If inspection refused or copy not given, register can order immediate compliance. Registrar can order immediate compliance. General punishment, default penalty section 149 to 170, where no specific penalty is given. Company 50,000 plus 500 per day of continued default, max 3 lakhs. Officers in default 50,000 plus 500 per day, max 1 lakhs. Case law, Jal Power Corporation. Company delayed appointing moment director by 180 days, offense compounded. Even though only two of the four directors filed the compounding application, all four directors had to pay penalty since all were in default. Quick revision. All the time limits at glance. Apply for DIN before appointment, former section DIR 3, section 153. CG allots DIN within 1 month of application, section 154. Director informs company of DIN within 1 month of receiving DIN, DIR 3B, section 156. Company informs ROC of DIN within 15 days of director's intimation, DIR 3C, section 157. Director gives change in particulars within 30 days of change, DIR 6 or Rule 12. Director gives change to company within 15 days, Rule 12.4. Defective DIN application rectification within 15 days. Company files consent of director with ROC within 30 days of appointment. New company comply with woman director requirement within 6 months of incorporation. Fill woman director or independent director vacancy. Board meeting or 3 months, whichever is later. Resident director days in India at least 2 days per financial year. Notice for candidature. Non-retiring director at least 14 days before meeting. Company informs members of candidature at least 7 days before meeting. Company files form DIR 12 appointment or change within 30 days. Company sends resignation notice to ROC within 30 days, DIR 12. Director files DIR 11 resignation within 30 days from resignation date. Register of directors extract given to member within 30 days of request or free. Proficiency test in IICA databank within 2 years of inclusion. Small shareholder director notice at least 14 days before meeting. Penalty waiver grace for new director in defaulting company 6 months from appointment. So that's it. Chapter 1 is covered. I think at the beginning I didn't cover the first section, which is what is a director. This is that part. You can pause it and read it. And I covered from section 2. Fine. So that's about it. Let's go to the question answer. Let's see. By reading these notes, can we answer some question answers? So let's go to the study material, and here are the question answers, multiple choice. There are 6 question answers and some descriptive questions, but the test will be MCQ based, so I don't know why the descriptive answers are given. Anyway, let's see how many we get correct. Mr. Q, a director of PQR Limited, is proceeding on a foreign tour, okay, covering entire Europe for 4 months. Fine, must spend some time in Amsterdam. He proposes to appoint Mr. Y as an alternate director to act on his behalf during his absence. The Articles of Association of PQR Limited provide for the appointment of alternate directors. Mr. Q claims that he has a right to appoint alternate director of his choice. Which of the following options is applicable in the given situation? Claim made by Mr. Q to appoint Mr. Y. as alternate director is valid as the Articles of Association of PQR Limited provide for such a appointment. Claim made by Mr. Q to appoint Y as alternate director is not valid as the authority to appoint alternate director has been vested in the board of directors only, and that too is subject to empowerment by articles of association. Mr. Y cannot be appointed as an alternate director in place of Mr. Y Q since Mr. Q is proceeding on a foreign tour covering entire Europe for 4 months only, which is less than the required absence of 6 months. Mr. Y cannot be appointed as an alternate director in place of Mr. Q since Mr. Q is proceeding on a foreign tour covering entire Europe for 4 months, which is more than the required absence of maximum 3 months. So, even though I can kind of recall, I read something like this, but I am not sure which is going to be the answer. So let's look at what the answer is. One is B. So for one, the answer will be that claim made by Mr. Q is not valid as the authority to appoint has been vested by board only, and that too is subject to empowerment by article association. I had a feeling that this was going to be the answer. Anyway, in compliance with Companies Act 2013, at least one woman director shall be on the board of the prescribed class or classes of companies. Ms. Ria is keen to seek the office of the woman director in a company. Which of the following companies is mandatory required to appoint a woman director where Ms. Ria can hold office? So a listed company whose turnover is 250 crores as per the last date of latest audited financial statements is mandatory required. Okay. So PQR Limited and unlisted companies valuation not exceeding. ECZ Limited unlisted company. The question asks which of the following is mandatory required to appoint a woman director. But I think B because it is a listed company, it fulfills that requirement. And also C doesn't because 300 crore is not exceeded. But I think it was is not more than 300 crores. So C is exempted. D whose paid up is not exceeding 100 crores and turnover is not exceeding 100 crores and turnover is less than. So C and D are not required. A, an unlisted company is paid. So yeah, for two the answer will be B. Let me hide all the other answers. I'll only just look at what the answer for this. Yeah, two is answer is B. 3. Kutub Agro Limited, a newly incorporated company, has not mentioned the name of the first directors in its articles of association. There are 8 subscribers to memorandum of association. From the following 4 options, choose the one which indicates as to who shall be deemed the first directors of KL when nothing is mentioned in the articles. All the 8 subscribers to the memorandum of KAL shall be deemed to be first directors. Yeah, that's the answer. I'm not even going to look at the other options. So for 3, the answer is B. What? The 3 answer is B. What does B say? Except Parivar Agro Private Limited, all other subscribed members of memorandum of care. Yeah, B is going to be the answer. There are 8 members to memorandum of association, including Parivar Agro Private Limited. 4. The turnover of XYZ Components Limited as on the last date of latest audited financial statements is 400 crores. An intermediate vacancy of a woman director arose on 15. Why is of the 6 MCQs, 2 are about women directors? An intermediate vacancy of woman director arose on 15 June 2021 due to resignation of Ms. Swati. The immediate board meeting after the resignation of Ms. Swati was held on October 10th, 2021. From the following options, choose the one which indicates the date by which vacancy of the woman director must be filled. So it's 3 months or date of next board meeting, whichever is later. So vacancy arose on 15 June 2021. 3 months after that is July, August, September. So September or the date of board meeting, which was on October. So the date is October 10th, 2021. So the four answer will be D. 5. I'll look at 4 and 5 at the same time. Mr. Nagarjuna, one of the directors of MGD Mechanics, due to his own business interests, decided to resign as director and accordingly sent his resignation letter dated 12th June 2021 to the company stating that he intends to resign with effect from 15 June 21. Since no communication in relation to his resignation was received, he sent an email on 17 June 2021 inquiring about the receipt of his resignation letter by the company, but there was no response. However, MGT received his resignation letter on 18 June 2021. Out of the following four, choose one which indicates the correct date from which his resignation will be effective. I think it will be effective from the date he intends to resign, regardless of the date of receipt. So I think the answer will be B. So 4 and D and 5 is B. Let's see if we are correct. 5 is D, 4 is D. So 4 we got correct, 5 we didn't. So question number 5, the date will be 18 June 2021. So that is the day in which the company receives the resignation letter, not the day in which he intends to resign. Okay, fine. 6. Mr. Z is proposed to be appointed as the director in RLP Mechanics. It is noteworthy that Mr. Z already holds directorship in one dormant company, two Section 8 companies, 8 public limited companies, and 9 private limited companies. However, out of 9 private limited companies, 2 are subsidiaries of public limited companies. In the given possible circumstance, it is possible for Mr. Z to accept another directorship in RLP Mechanics without attracting any invalidity. So dormant company and Section 8 company, directorships are not counted. So one dormant and two Section 8, we'll ignore that. The question now arises 8 public limited companies and 9 private limited companies. However, so out of the 9 private limited, 2 are subsidiaries of public limited companies. So if that happens, how is that going to be adjusted? The limit is, I think, 10 for publicly listed companies and 20 for public and private companies. So let's see what the answer is. So answer is B. B say B says that it is not possible for Mr. Z to accept the directorship in RLP since he is already holding directorships in 8 public limited companies and 2 such private limited which are subsidiaries of public. So because the limit has been reached, he can't hold another office. Okay, fine. So that's about it. I think we can end the stream now, and we'll do revisions again. Obviously, this is the first time I read this. I've completed the ICI those lectures, but I'll revise this note again and again, multiple times, and I'll probably give my exam exactly 10 days from now or 14 days from now because I both of those slots are available. And after I give my exam, I'll share how much marks I got. So that's about it. We'll see you in the next chapter.